Welcome to the Robert H. Jackson Center. My name is Kristen McMahon, and I have the privilege of serving as the president of the center. The Robert H. Jackson Center is a nonprofit, nonpartisan, and a registered 501c3. And because education was such a critical part of Robert H. Jackson's success, we do not charge for any of our programs, events, or tours. Our success and sustainability is 100% reliant on philanthropy. And you can learn more about how to support our programs, our mission, and our work on our website, roberthjackson.org. The center is celebrating its 25th anniversary this year, and so our program theme is 25 years of asking questions. And we'd like to thank Southern Chautauqua Federal Credit Union for sponsoring this program series. One of the fundamental precepts of the center is that we do not tell you what to think. We give you access to experts and information and the tools to help you determine how you think about things, to analyze those thoughts, and then take them out into the world and do something with them. All of our 2026 programs lean into this deeply. And today's program explores the health of democracy currently, its challenges, its resilience, and what all of us can do to help keep it healthy, under the title of A Republic, If You Can Keep It. When Benjamin Franklin was asked, as he emerged from the Constitutional Convention in 1787, what kind of government had been created, he reportedly replied, "A republic, if you can keep it." And that conditional if still feels urgent today. Associate Justice Robert H. Jackson thought often about those conditions. Jackson knew executive power from the inside. He had served as Solicitor General, as Attorney General, and as an Associate Justice of the U.S. Supreme Court, the only person in U.S. history to have sat in all three of those chairs. He also observed executive power from the outside and helped create the modern-day accountability system when he stepped away from the court for 15 months to serve as the chief of counsel at the International Military Tribunal at Nuremberg. The breadth of his experience gave him a wider lens through which to view this question. In his landmark concurrence in Youngstown Sheet and Tube Company versus Sawyer, colloquially referred to as the Steel Seizure case, Jackson laid down what remains the most influential framework for understanding presidential power in constitutional law. And there he wrote that the purpose of the Constitution was not only to grant power, but to keep it from getting out of hand. And what was at stake, he cautioned, was nothing less than the equilibrium established by our constitutional system. Jackson was equally clear about what stood between the citizen and an overreaching executive, and that is the courts. In a series of lectures published after his death, titled The Supreme Court in the American System of Government, he wrote that the task of a justice was to maintain the system of balance upon which free government is based, and that the court was the most detached, dispassionate, and trustworthy custodian the American system affords for translating abstract constitutional doctrines into concrete commands. I should mention, however, he did not think the court was all-knowing, and he famously quipped, that the Supreme Court is not final because they are infallible, but they are infallible because they are final. What then would Jackson make of Franklin's challenge? He answered it, in a sense, in Youngstown, which will be part of our discussion today. So we are thrilled to have joined us today Peter Cohen, who is the author of the book In the Supreme Court's Own Words. It asks us to hear the court speak in its own language, from its own cases, about the first principles that constrain presidential power and preserve the republic. Franklin's conditions are still open. And Jackson's answer was clear. The keeping of this republic depends on whether we hold those principles fast. Peter C. Cohen is a seasoned attorney with over 40 years of first-chair civil litigation, legal writing, editing, and appellate advocacy experience, during which he developed deep expertise in the jurisprudence of the U.S. Supreme Court. Over those decades, Mr. Cohen studied and applied hundreds of Supreme Court decisions across a wide range of legal subjects. He wrote and edited more than 1,000 briefs filed in courts at every level of the judiciary, many of which required distilling complex rulings into persuasive arguments for judges, clients, and colleagues. Mr. Cohen also served as an adjunct professor of law, teaching landmark Supreme Court decisions to both American and international students, and his courses explored constitutional foundations, separations of power, due process, the rule of law, judicial review, and pivotal cases addressing presidential authority, many of which form the heart of his book. His teaching experience underscored how complex constitutional concepts can become accessible when presented with clarity, structure, and historical context. Motivated by growing concerns over the erosion of democratic norms, Mr. Cohen resolved to direct the full measure of his legal training, civic commitment, and scholarly discipline toward a single accessible work, one that examines how the Supreme Court has historically served as a constitutional check on presidential power. Peter, thank you so much for joining me in conversation today.
Thank you so much for having me. It's an honor to be at the Jackson Center.
I always like to start with a foundational question, and it's usually about what prompted you to do this. So your book is entitled In the Supreme Court's Own Words. So why was it important to you to let the court speak for itself?
So the book was written essentially for three reasons. The first is that I wanted to do a deep dive on Supreme Court jurisprudence on the question of limiting executive power. It's an issue that's been in the news, not just in the last 10 or 15 years, but in the last 80 to 100 years, given the expansion of executive power through the 20th century and then into the 21st century. I thought that the best way to do that was to get out of sort of the contemporary analysis of that and to do a deep dive into the constitutional history of restraints that are put upon the presidency. And that's exactly what the book does. It goes from 1803 to 2024, and it curates the landmark decisions by the Supreme Court where the Supreme Court essentially reined in a president when a president is acting outside of either constitutional or statutory authorization. So that was the first reason for writing the book, because I thought that in order to understand what is going on today in the last 50, 80 years, it's better to take sort of a wider lens on the subject. The second reason why I wrote the book was to remind the Supreme Court of its institutional role throughout American history. And in fact, the book is dedicated to both current and future Supreme Court justices to remind the court, this is what you've said through almost 240 years of jurisprudence on the question of presidential power, executive power, the expansion of it, the limitations on it, the fulfillment of the framers' vision for an energetic president, but one limited to his or her appropriate sphere of duty, as the Supreme Court famously said in a case in the 1860s. So the second reason was to remind the current Supreme Court of the historic institutional role. The third reason, and this is why the book was titled the way it was, is to make Supreme Court decisions more accessible to people, particularly non-lawyers. Many people are afraid to read Supreme Court decisions. Many lawyers are afraid to read Supreme Court decisions. But it's important that we read the court's opinions for ourselves and not have it be filtered through various media, the proliferation of social media and internet analysis of Supreme Courts can sometimes be wanting. So another reason for the book was to make Supreme Court decisions more accessible so that people can decide for themselves whether the Supreme Court's decisions are good or not. So those are the three reasons why the book was written.
That's great, and that actually leads me very nicely into my next question, which is sort of a combination of you have practiced law for a long time, you have taught the law as well. How did that shape what you were doing with this book? And for the non-lawyers in the audience, how should they be thinking about Supreme Court decisions and what should they take away from the book?
So it's important, and Justice Jackson made this point in his Steele seizure concurrence, that it's important to separate the constitutional office of the presidency from its temporary occupant. Many times, people will decide whether what a president does is constitutional or not, whether or not it's been authorized by Congress or not, depending upon whether or not we like the president or whether we agree with his policies or not. Justice Jackson was very clear in his concurring opinion that that is not the way to implement the rule of law. He quoted Chief Justice Marshall, one of the famous Chief Justices in the 19th century, by saying that this is a constitution we are expounding, not personalities and not political parties and not partisanship. One thing that I took away from both my practice as well as teaching constitutional law is to be really clear on separating the office from the person. And I think that makes particular sense today. I think Justice Jackson would particularly make that point today, and that we ought to look upon the expansion and limitations of executive power, looking at the historic understanding of the office, what the framers intended the presidency to be, and not necessarily whether we like the president and or his policy. So that was the biggest takeaway in my practice as well as teaching law, to be able to separate constitutional law from the person who occupies the office.
Perfect. Thank you. You structured the book around 5 forms of presidential overreach. I'm not going to try and do this from memory. I did actually write them down. So the pretender monarch, the jailer, the military ruler, the lawmaker, and the lawbreaker. How did you arrive at that structure, and was there anything that surprised you while you were writing it?
So it was the research of Supreme Court decisions itself that allowed the book to sort of organically be distributed according to those categories. For example, the president being a military ruler, the Supreme Court has an extensive number of decisions on what are the constitutional rules before a president could deploy military force upon a civilian population. And that particular chapter of the book traces how the Supreme Court was very deferential to the president in the early 19th century, but it wasn't until the Milligan case in the 1860s, a Civil War case, where the Supreme Court began to lay out constitutional requirements before a president can deploy military force upon a civilian population. Justice Jackson took up that baton both in his dissent in Korematsu as well as the concurrence in the Steele seizure case, where he said that just because the president deploys troops or just because the military decides that something is necessary, that doesn't suspend the Constitution. And Justice Jackson was very firm about that. And so that chapter of the book sort of traces the Supreme Court's initial deference to the president in the first half of the 19th century, where the president basically could deploy military troops upon a civilian population at will, until the 1860s to the present time, where the Supreme Court has articulated these standards. So that particular chapter of the book tries to trace those Supreme Court decisions. On the chapter regarding the president as lawbreaker, this was the relationship between the president and the criminal justice system, which started with Aaron Burr, one of the country's early vice presidents, who President Jefferson charged with espionage and other kinds of crimes, where President Jefferson was served with a criminal subpoena, and he didn't want to comply with it, saying that the president is above that kind of thing. And Chief Justice Marshall at the time wrote an opinion which set the trend of when the president needs to comply with the criminal justice process. And that went all the way to Richard Nixon during the 1970s with the Watergate scandal, when he was served with a subpoena to provide tapes of secretly recorded conversations in the Oval Office. It went to Bill Clinton when he was sued civilly by Paula Jones for acts he committed or allegedly committed before he was president, all the way up to the present time in 2024 when the Supreme Court, for the first time in its history, grappled with the question of when is a president absolutely or qualifiedly immune from the criminal process given decisions that he's made. So that particular chapter sort of traces the Supreme Court jurisprudence on that particular issue. In terms of surprises, I would say on the chapter of the president as lawbreaker, what surprised me was that the interaction between the president and the criminal justice system began so early in this country's history. With President Jefferson, who was the third president of the United States, and Chief Justice Marshall setting the precedent that future Supreme Courts would use in order to set the standards when a president needs to comply with the criminal justice system. So that was one big surprise that I found in the research.
That is surprising. I wouldn't have thought quite that early.
Yeah.
All right, so we've mentioned Jackson's still seizure concurrence a couple of times. I think it would be helpful, especially for the non-lawyers in the audience, if you could very quickly break down what is it in Jackson's concurrence, and what are your thoughts as to why it continues to endure today?
The last part first, it endures today because it made so much common sense. So the Steele seizure case was Harry Truman was running a war, the Korean War, and in the 1950s, it was challenging for a president to run a war without steel. And the steel workers of America were threatening to go on strike. President Truman set up a mediation process to try to get it mediated. It didn't work. So he ordered his Secretary of Commerce to issue orders that would ultimately privatize the steel mills of the United States. So President of the United States ordering the seizure of private property. And the Supreme Court, 6 of the justices agreed that that was a violation of the Constitution. Each set out their own analysis. Justice Black wrote the majority opinion, and he was a textualist. So he said President Truman did not have the authority to privatize the steel mills based solely upon the wording of the Constitution. Justice Frankfurter was a traditionalist. He would approach the answer, or he approached answering that question by looking, what has been the tradition of a president nationalizing private industry? Justice Jackson took a different route. He looked at, and he wrote that concurrence after his Nuremberg experience, where he saw the complete eradication of legislative authority and the aggrandizement of executive power. Think of that combination. And he saw that up front with the rise of Hitler and the rise of the people around Hitler. And he also saw it in conjunction with his interactions with his Soviet counterparts during the Nuremberg trial. So he saw totalitarianism up close and personal. So when it came time for his concurrence in the Steele seizure case, he was very much more of a Congress guy. Before he went to Nuremberg, he was all about executive power. He was FDR's lawyer. And as Solicitor General, as Attorney General, he argued for the expansion of executive power. He successfully argued the constitutionality of the Social Security, a program that still exists today. He successfully argued before the Supreme Court the constitutionality of the wage-hour laws and other intrusions of the executive branch into private industry. He was an executive power guy. After Nuremberg, he became much more parliamentary in nature. So, in the concurrence, he saw presidential power in conjunction with congressional power. He saw it as fluid between the president and the Congress, and he saw it fluid in 3 different ways. First, if Congress expressly or impliedly authorizes a president's action, then the president is acting in his strongest way because he has the authority of Congress to do what he wants to do. That would be the first category. That's the strongest part of executive power. The second category he created was, well, what if Congress is completely silent on the subject? What does presidential power look like then? And Justice Jackson says, well, then it depends upon whether or not there's an independent provision of the Constitution that gives the president the power to do what he wants to do. Then there's the third category, and that is where Congress has either expressly or impliedly stated its opposition to what the president is doing. And that's where Justice Jackson believed President Truman's action in seizing the steel mills fell into, because Congress several times dealt with the question of when a president can nationalize industry and voted it down almost every single time. Well, Justice Jackson said, this falls into the third category. Well, first, in the first category, that the president did not have the authority by Congress, but secondly, Congress was already on record as not agreeing with this idea. So those are the three categories that Justice Jackson created to determine whether or not executive power is constitutional or statutory authorized. And that framework has been used in several cases after the Youngstown case, the steel seizure case, and has been looked upon, even though it was a concurring opinion. It wasn't the law of the case. Justice Black's decision was the law of the case, but it was Justice Jackson's concurring framework that has set the tone for the Supreme Court analyzing whether what a president does is either constitutional or it's authorized by Congress.
I think one of the things I find most interesting about that opinion is that it was an opinion of one.
Yeah.
Nobody else signed on to it. None of the other justices said, we agree with this analysis.
Right.
And yet it is the prevailing analysis.
It is, and concurring opinions are not supposed to work that way. Concurring opinions, there's three kinds of opinions the court can issue. Is a majority, which is the law of the case. That's the law. Concurring opinions, where the justice agrees with the result but for a different reason or a different approach. And then, of course, dissenting opinions, where the justice says, I neither agree with the result nor the way you got there. It is rare. I can't think of another case where a concurring opinion, which is not the law of the case, essentially became the law of the case and the framework that was used for future Supreme Courts to analyze executive power.
One of the other things, too, just from a historic note, is that some of the arguments that were being offered in the steel seizure case, they had gone back to some of Jackson's arguments when he was Solicitor General and Attorney General, and Jackson was pretty floored by that approach because in his mind, the two circumstances were so vastly different. Right. And that prompted him to actually write a book about his experience in FDR's administration called That Man, which was published well after his death. But he was just so surprised by those arguments and then looked around and realized he was the only one still alive from those earlier discussions, and so decided to memorialize those. You started talking about this a little bit, but I want to dig in a little deeper, and I think we have to take Jackson's life in two parts as you have laid out. So Jackson was a self-described country lawyer, and then as Solicitor General, Attorney General, and Supreme Court Justice, as you mentioned, tended to follow FDR's lead. And so where FDR wanted to go, Jackson was in general in favor of that. I'm not going to say that's totally true, but in general. How do you think his time inside the administration shaped his concurring opinion here? And do you think that gives it more credibility or makes it more surprising?
I think it gives it more credibility because you're right. When he was Solicitor General and Attorney General, as I said before, he was FDR's lawyer. And FDR felt that the best way to get out of the Great Depression, which was a calamity in this country, millions of people out of work, thousands of banks failed, millions of people lost their savings, and it was a crisis. And FDR came in thinking that the best way to try to dig ourselves out of the Great Depression was an expansion of executive power in all sorts of industries, setting prices in industry, increased regulation in terms of various industries and the like, and to give the president more power to do so rather than the Congress, because presidents can move faster than the Congress can. And Justice Jackson is a good example of, where you stand on a matter depends on where you sit, because in his two positions, as Solicitor General and Attorney General, he argued in favor of the expansion of executive power. So when it came time, so when he went to Nuremberg, he was an executive guy. Then he saw in Nuremberg the excesses that can occur when executive power takes over and legislative power goes away, both with the Germans and the Russians. And it changed him. He made it clear that it changed him. And so when it came time for the Youngstown concurrence, he clearly had both mindsets in his mind. What his role was during the time he was Solicitor General and Attorney General, and arguing in favor of the expansion of power, executive power. But Nuremberg tempered him and realized that Congress plays a preeminent role. And that is part what fueled his three-part framework for examining executive power. As I said before, it was a fluid. He saw it as fluid. It was very different than what the other justices were thinking. Very fluid. If Congress acts and gives the president's power, then the president is at the apex of his power. But if Congress is silent, well, then it depends. Is there a provision of the Constitution which gives the president the power? And of course, if Congress is on record as opposing what the president is doing, that's the lowest ebb. That's what he said. That's where the president is at his lowest ebb, and it's presumptively unconstitutional. So there's no question that he contrasted his positions that he took before Nuremberg with after Nuremberg. What he also did, which colored his judgment, is that he was one of the few justices at the time that took into account international experience. In the concurrence and in some of his other opinions, he took into account the rise of totalitarianism in Germany, in Russia. He talked about how France, during the time, and Great Britain during the time that they were empires, how they nevertheless kept alive the legislative impulse, and that it didn't all become executive power. So he was an internationalist, and he incorporated that into his analysis, which separated him from some of the other justices.
I also find this particular opinion one of his most pragmatic, and for a
Yes.
jurist who had that kind of reputation, to say that is I feel like saying something fairly strong, in that he was really concerned of how does this live in the world
Right.
practically? How can we give people guidance to live this and move this forward?
Right.
Do you think that, so you quote something in your book, the accretion of dangerous power does not come in a day. It comes slowly from unchecked disregard of constitutional restrictions. So how does that resonate today? And do you think that's why subsequent courts have returned to this opinion so often?
Yes, and Jackson was impliedly referring to Hitler, because Hitler took control, or the German government allowed him to take control in 1933. He didn't go to war until 1939, and so Hitler used those years to basically enlarge executive power beyond all constitutional constraints while eradicating any legislative role. And
judicial role.
And judicial role. So he was clearly, making reference to that. I think it plays an enormous role today because, and in the last 20 to 30 years, and again, taking up Jackson's cue of looking more internationally, we know that in the last 20, 30, 40 years, many coups, many takeover of governments doesn't happen in a day. It can, and it happens, where tanks are thrusted into democracies and they take over a military coup and that kind of thing. And that still happens, and it has happened. But there's just as many examples where it's a day-by-day accretion of power to the executive. And it doesn't happen in a day, and sometimes it doesn't happen in 5 years or 10 years. It happens over time, and it's usually a combination of an executive who wants to have that power in combination with a legislative branch which is not performing a check on the president, as well as a judicial check as well. Jackson knew that the framers in our system saw Congress as the main structural check on the president, not the judiciary, back at the time of the ratification of the Constitution. The judicial branch, as Alexander Hamilton famously said, is the weakest branch of the three branches. It has no army, it has no budget, and many of the framers thought that it was Congress that would act as the structural check upon the president. And so in the last 15, 20 years, an argument can be made that Congress is not performing that kind of structural check. And I think if Justice Jackson was around today, he would point that out, that it's a dangerous situation when the executive, who always wants more power. The history of presidents is the history of an expansion of power. FDR is just one example. And it's on Democrats and Republicans' side. It's a nonpartisan issue. All presidents try to expand their power. And it's up to the other two branches to rein them in. And the framers thought the Congress would do it the most. When the Supreme Court took on the power of judicial review back in Chief Justice Marshall's days in the famous case of Marbury versus Madison, then that is what launched the judicial branch as being one of the more greater structural checks upon the president, because the judicial branch has the power to declare acts of the president and the Congress, but acts of the president to be unconstitutional. So Justice Jackson, if he were here today, I think would point out how Hitler rose to power because of the combination of a reduction in legislative authority and judicial authority, and a great expansion of executive power. And I think he'd be alarmed, particularly if Congress is not performing the structural check that the framers intended Congress to play.
Before we discuss a little bit about today, I want to dip a little bit further back into history even, and you've mentioned the Civil War era case a couple of times, Ex parte Milligan. And this is a case that the court in the 40s and 50s, as they're navigating World War II and Korea, as you mentioned, are still citing quite often. Why?
So in the Milligan case is a case that involved Abraham Lincoln, one of the more arguably beloved presidents of the country. If you ask someone to name the top 5 presidents in American history, probably most people would say Abraham Lincoln is in the top 5. Mr. Milligan lived in Indiana. There was a civil war going on, the greatest crisis a country could ever have. 500,000 Americans lost their lives. 11 states seceded from the Union. There's no greater crisis a country can experience than what President Lincoln experienced. And he suspended the right of habeas corpus, which is a fancy word for that if the president imprisons you, you have a right to contest that imprisonment in federal court. There is a constitutional provision that allows the president to suspend it during times of rebellion. But the issue in Milligan was that he was a resident of Indiana, had allegiance to no side. He just wanted to live his life. He wasn't a soldier. He didn't take sides. He was nevertheless arrested by the military authorities in Indiana. He was convicted of a contrived crime, and he was sentenced to death. This was a situation, and the case went to President Lincoln, and President Lincoln affirmed the decision of the military that Mr. Milligan be hung. This case went to the Supreme Court, and the Supreme Court famously freed Mr. Milligan, and its major point in the Milligan case was that Abraham Lincoln and the executive branch still need to follow the Fifth Amendment right to trial by jury. Mr. Milligan was not a military person. He should not have ever been subjected to martial law or to military commissions. He was just a civilian going about his life. And the Milligan case was saying that even though we have a national emergency, a national crisis, and there's no greater one than a civil war, the Constitution still matters. The President of the United States still needs to comply with the Constitution of the United States, particularly during emergencies. And Mr. Milligan was freed as a result and was entitled to a trial by jury, which is guaranteed by the Fifth Amendment. And this is essentially found its way not just into Justice Jackson's concurrence, but a major theme throughout the jurisprudence of the Supreme Court ever since the 1860s, that even in times of true emergencies, the Constitution is not suspended. The president cannot suspend the Constitution. Justice Jackson, in both the Kawamatsu dissent and as well as in the Youngstown concurrence, said that the military has their role to play. The country needs the military. But that doesn't mean that the judicial authorities or the president just rolls over anytime the military says that something is needed to be done. The Constitution still matters. So the Milligan case, as well as the Youngstown concurrence, were the two major inspirations for the book, because it set the tone of the Supreme Court fulfilling its role of reining in a president when a president is acting contrary to the Constitution, even during times of emergencies.
Well, and one of the other things that was coming to mind as I was reading this book too were the discussions we're having contemporaneously about the seeming politicization of the Supreme Court and how the commentary today is it's never been so political. And my argument is the Supreme Court has always been a political body. That is just part of its history. And especially if we think back to Jackson's era on the court, there was still intense political pressure there. If we start, in the 30s, as FDR is trying to figure out how to work with a court that's hostile to the New Deal and what he may do about that, and moving into his court packing idea. And then you even have very public discussions and disagreements between Supreme Court justices themselves. And I'm thinking, of course, of Jackson and Hugo Black and things like that. So do you think that affects the court's authority? And if so, how? And then do you see parallels with today?
So I would say yes, it does affect the credibility of the court. In fact, we just saw it recently. Justice Sotomayor made a comment about Justice Kavanaugh that she had to pull back and apologize for. To her credit, she realized she went too far and made a more personal comment and realized that that's contrary to the collegial aspect of the court. You're right. Jackson was, at the first couple of years he was on the Supreme Court, he thought about potentially resigning because he thought that several of the justices, including Black and Douglas, made decisions not on the basis of law, but more on the basis of political expediency. Justice Jackson was a law guy. He was an appellate lawyer. And he believed very much in the rule of law domestically and internationally, and so he thought that the Supreme Court was too political. And some of that politics did spill out into the public and the like. But yes, the Supreme Court has always been a political body, and we're seeing that played out today. I think it's up to the Chief Justice to try to rein that in. That's part of the job of the Chief Justice. I do think, though, at the end of the day, while there are differences among the justices, just like there were in Jackson's day, that at the end of the day, when you read the various opinions by the court, the majority, concurring, dissenting opinions, I think that there is a genuine attempt by the justices to try to get the law right. I do think that that's the case. It's not to say that politics doesn't potentially play a role. I would say that the Supreme Court, the judicial branch generally, is probably the least political branch compared to the other two political branches, which are deliberately political. The judicial branch is supposed to be above it all. It's why the framers gave them lifetime tenure, to be above politics and the like. But anytime you put two or more people in the same room, there's bound to be politics. But I do think that there is an effort on the part of the justices to be collegial and to fight it out, so to speak, in their opinion writing and in their decision making, but not necessarily personal. There was some personal aspects with Jackson. He did not care for Justice Black and felt that many of the decisions were politically based. So they may have their personal views of each other, but at the end of the day, I think they do try to fight it out on the law in their opinions.
You mentioned earlier the Trump versus United States case, and in that particular opinion, both the majority opinion and the dissenting opinion quote from Youngstown. So really just to give that sense of how universal this opinion really is. What should we take away from that? Does that strengthen the Youngstown opinion? Does it dilute it? What if anything should we read into the fact that both sides are essentially using the same language to justify their positions?
I think it goes to the majesty, if I may, of Justice.
We will always accept that. Yes, absolutely.
of Justice Jackson's concurring. If you've got both sides of a case, and in the presidential immunity case, 2024, highly recommend that you take the time and read Chief Justice Roberts' opinion and read the two dissenting opinions, Sotomayor and Jackson, and see the justices fighting it out. On paper, who knows what happens when they're all together? There's no cameras in the room when they're all together deliberating and voting, but they're certainly fighting it out in their opinions. And when you have two sides that are so totally divided, but yet citing Justice Jackson's concurring opinion in the Youngstown case, it shows the majesty of the opinion and the like. I'm not surprised by it because sometimes approaches to deciding legal questions can begin with same approaches, but they lead to different conclusions. So I'm not necessarily surprised by that, but the fact that both sides in a strongly heated case is citing Justice Jackson for their own viewpoint, I think shows the universality of his opinion.
Mm-hmm. And in fact, Justice Jackson's dissent uses the phrase, "The court has now declared for the first time in history that the most powerful official in the United States can become a law unto himself." Which when I was reading the dissent the first time, I was thinking, is that echoing Jackson? And do I find that comforting? Do I find that alarming? So I'm turning that question to you. How do you think about that?
Well, so the presidential immunity case, again, 2024. So throughout the history of the United States, the question of whether the president could be criminally prosecuted for acts taken as president didn't rise to the Supreme Court until almost 240 years after the Constitution was ratified, because it's never happened before. I mean, this was the first time that a president was indicted for alleged criminal acts while president. And so that issue had never been looked at before. And so it highly recommend that those opinions be read. Chief Justice Roberts tried his best to sort of look at the history of the interaction, as I said before, the president and the criminal justice system. And essentially the decision came down, the majority decision came down to three different things. And I think it's a mistake for people to conclude that the Supreme Court's majority decision in the case says that the president can do whatever he wants and get away with any crimes. That's not exactly what they held. What they held was that if the president takes an action that is expressly and exclusively given to the president in Article 2 of the Constitution, the other two branches can't touch it, including the criminal law. So that if the president takes an action exclusively given to him by Article 2 and expressly given, the other two branches can't touch it, including criminal law. Then the second category was what if the president engages in an action that isn't necessarily part of the core function of a president, but it's kind of on the outer perimeter of what a president does. The court did say that such actions are presumptively constitutional, but the laying out of that aspect of it needs to await future cases. Then the third part of the majority opinion was that if the president truly engages in a private action unconnected to the presidency and unconnected with his official actions as president, the president can be criminally charged. So, for example, if the famous example that our current president gave, where if he walked out on Fifth Avenue and shot someone, could he be prosecuted for that? I believe even the majority in the presidential immunity case would say yes. The dissenters, Justice Sotomayor and Justice Jackson, really took issue with it, and you can see the arguments written on the page where they believed at the end of the day the president is not above the law, and what the majority is saying is that even if, what the dissenters are saying is that even if the president engages in an action that is authorized by the Constitution or is authorized by a statute of Congress, but nevertheless commits a crime in the process, that the only way to uphold the idea that the president is not above the law is to be able to allow the criminal justice system to deal with that matter. Highly recommend the 2024 decision. I said earlier to read Supreme Court justices for yourself and not allow the media or different parts of the media to filter it for you. The presidential immunity case of 2024 is a good example of that. So you can come to your own conclusions about whether the dissent was correct, that the majority went too far, or that the majority, who vigorously criticized the dissenters, saying that if the dissenters had their way, it would potentially cripple the ability of the president to be able to execute his Article II functions. So you really good case on where you see that they're fighting it out.
What changes do you think would be necessary to Jackson's framework as we're talking about more modern crimes like cyber warfare or ecocide or things along that line? Does the framework still hold for those modern day things that would never have been contemplated in Jackson's time?
I would say yes. I think that Jackson's concurring vision would apply. Again, he was very practical and very pragmatic and saw the presidential power in juxtaposed to congressional power, so that if Congress spoke on the subject and gave the president express authority to do something, assuming it's constitutional, because sometimes Congress can pass on powers to the president that are held unconstitutional. In fact, that was FDR's main objection and what inspired him to do the court packing plan in 1937. But if Congress authorizes the president to engage in a certain action, whatever, even in understanding the modern sensibilities of that, the modern technological sensibilities of that, that part of the framework would still hold. The second part, has Congress spoken on the subject? Are they totally silent on the matter? I think the framework still applies. Is there a provision of the Constitution, particularly in Article II, which created the executive branch? Is there anything in Article II that gives the president the power to do that? And then thirdly, if Congress is on record as opposing the action taken by the president's power is at its lowest ebb and is presumptively unconstitutional. And there's been several examples of that in the post 9/11 world. If I can quickly give one. Yeah. After 9/11, the executive branch, led by George Bush, created military commissions so that combatants who were captured in Afghanistan and elsewhere in the Middle East could be tried by military commissions. But what President Bush did with his Defense Department is that he created military commissions that were not authorized by Congress. Congress had statutes on the books which created military commissions, but President Bush didn't feel they went far enough. So he created his own as commander-in-chief. Well, two cases went up to the Supreme Court in the 2006 timeframe. The one is Hamden, which is discussed in the book, where the Supreme Court said that the president cannot unilaterally create military commissions, and particularly in a situation where Congress has spoken on the subject. Congress has created military commissions. If you don't think they're strong enough, go to Congress and get more authorization. So that framework applied to post 9/11 issues. So I would say that the framework holds. The details of it are clearly things that justices in the 1940s and 50s could not have envisioned, but I do think that the framework would hold.
So your book is written both as a tribute to the court's best moments of institutional courage and as a reminder, as you mentioned at the beginning, to current and future justices. Let me start with the fundamental question. What, in your view, does institutional courage mean in this, and are there instances that give you hope?
Yes. Institutional courage is the Supreme Court and the judicial branch living up to the vision of certainly Alexander Hamilton, who was the major proponent for judicial review. Judicial review, the power of the judicial branch to declare actions taken by the other two branches to be unconstitutional, was never written into the Constitution. It's not an Article III power. But it was much discussed at the Constitutional Convention in 1787. There was just no resolution of it, and plus they were running out of steam. They all wanted to go home. But judicial review was well known at the time. And it wasn't until Chief Justice Marshall in Marbury versus Madison took that power for the judicial branch of government. That was an act of institutional courage. And there have been many instances, and the book describes many of these cases where the Supreme Court showed institutional courage of rising to the occasion, applying judicial review, and negating, ruling that what a president has done is either unconstitutional or it's unauthorized by Congress. So, and this is one of the reasons why I wrote the book, was to remind the current Supreme Court, this is what you've done. Institutionally, you've shown courage in the past, and you need to show courage going forward. What was the second part of that question?
Is there a case or an occurrence that gives you hope in this instance?
Yes, I would say the Milligan case, the Youngstown case, the series of cases after 9/11, another situation where the country was facing an emergency. This country had been attacked, and 3,000 people lost their lives. And Congress provided the president, President Bush, and succeeding presidents with much authority to try to deal with the terrorist network that began that war. But at the same time, the military commissions would be an example where President Bush went too far. Even though there was an emergency, we would all agree the country was attacked, the president needed to take swift action, but at the same time, hearkening back to the Milligan case, hearkening back to Justice Jackson's Korematsu dissent and the Youngstown concurrence, I do think that the Supreme Court showed institutional courage post 9/11 by saying, yes, we have an emergency, but the judicial branch still needs to fulfill its role of determining whether the Congress and the President are acting within their appropriate sphere of duties under Article I and Article II. And there was several cases where the Supreme Court rose to that occasion. We saw it again most recently with the tariff decision. Regardless of how people may feel about the current president's policies on tariffs, some people agree, some people don't agree, the issue before the court in the tariffs case was not policy. The question before the court was authorization. Did the president have authority under the statute that he was relying upon? Did he have the authority to implement the wide range of tariffs that he was imposing upon the world? And the Supreme Court, I believe it was a 6-3 decision, held that the president went too far. That's Justice Jackson. That's his concurring opinion, where the court, that would probably fall into category 3, where Congress did pass laws that gives the president some powers to impose tariffs in a situation where the president declares an emergency, but not this one, not this way. And so, yes, so I think that there is institutional, I think, many examples where the Supreme Court has rose to the occasion. If I could say another one real quickly, the Supreme Court, because you mentioned institutional courage, the Supreme Court showed rare institutional humility when it publicly apologized for the Korematsu decision. That was the decision where the Supreme Court held that the executive branch had the power during wartime to segregate people on the basis of their national origin. And Justice Jackson dissented in that. Highly recommend that you read that, because he talks about, and that was before he went to Nuremberg.
Yep.
That was before he went to Nuremberg. But Chief Justice Roberts publicly apologized to the American people for that decision. The only time I think the Supreme Court has ever apologized for a decision. Yeah.
All right, so we're going to open it up for audience questions, and to give them a moment to think, I have one wrap-up question for you. So Benjamin Franklin's phrase and the theme for this evening, a republic if you can keep it, feels to me both a promise, a hope, as well as a warning.
Yeah.
So after writing this book, how would you answer the question, we keep a republic by?
I would pick up the baton of Justice Jackson, whose legacy, I think, answers that question in terms of the rule of law and the separation of powers. The concurring opinion in Youngstown talked about the framers' vision of the way to keep a republic is to stay firm to the framers' vision of dispersing powers among three branches of government so that no one branch becomes too powerful. The framers understood the history of democracies and realized, and Jackson saw it in Germany and Russia, where if power gets concentrated in a particular branch, that can be a roadmap to authoritarianism and to dictatorship. Benjamin Franklin's call was to the generations showing or pointing out or admonishing the challenges of self-government. Justice Jackson brought that to life during his tenure on the court, speaking about the separation of powers is the secret sauce for maintaining a republic, and also the rule of law, both domestically and certainly international. He foresaw, his vision internationally was that rule of law would determine the outcomes of wars, that ultimately it's more than just moral condemnation, but legal accountability among those who start wars. So he had this international view of the rule of law as well. So that's where I think Justice Jackson's concurring opinion and Benjamin Franklin's admonishment to the generations dovetail with one another.
Thank you. Questions? There's one very much at the top.
Thank you, Professor Cohen. Greg Peterson with a question. Listening to your description of Chief Justice Roberts' presidential immunity decision and how we should read that with three layers, basically three factors. And at the same time, earlier in the conversation, of course, discussing the opinion of Justice Jackson, the concurring opinion, there were three layers of how we should analyze and determine. Do you see that as just coincidence, or is that something that may have been an overlay?
I see it as a coincidence. Justice Jackson's three-part framework is on the general question of how the Supreme Court should evaluate executive power, particularly in situations where presidents want to expand their power. So I see his three-part analysis from his concurring opinion as sort of a general framework for evaluating executive power. Chief Justice Roberts, in the presidential immunity case, separated it out in three different layers, but I don't think necessarily he was trying to parallel Justice Jackson's analysis as well. I think that if you read Chief Justice Roberts' opinion in the presidential immunity case, that's just how his analysis ultimately unfolded. So I wouldn't necessarily see that he was trying to parallel Justice Jackson's framework.
Thank
you. Yes, I'm wondering something that I've wondered about for quite a long time. Since the first time I heard it was when Andrew Jackson was told that he could not enact the Indian Removal Act, and he did it anyways. I mean, and it went on for years, the whole Trail of Tears and all that. So when that happens, what happens? I mean, when the president said you can't do that and he does it anyways, and the whole country watches it happen, then what happens?
So your question is a good one, and it raises the larger question, essentially, of what happens if a president disregards a decision of the Supreme Court. That happened in the 1830s with President Andrew Jackson. The Supreme Court ruled in a case involving the Cherokee Nation that the federal government and the state of Georgia could not enact laws that impacted their lives because they were an independent nation. President Jackson did not like that decision, and he is famously reported, it's never been proven, but he's famously reported as saying that Chief Justice Marshall, who was a Chief Justice by then for like 25 years, said, Chief Justice Marshall has made his decision, now let him go enforce it, which was Jackson's way of pointing out that the Supreme Court, the judicial branch generally, is, as Alexander Hamilton said, the weakest of the three branches. They cannot enforce their own decisions. They depend, the judicial branch, the Supreme Court, primarily depends upon the Congress and the President to enforce its decisions. Now, we have had 240-year history since the ratification of the Constitution, nearly 240 years. This country is fortunate that we have a culture of compliance for nearly 240 years, where we have accepted, including presidents, have accepted that decisions and orders of the judicial branch of government must be respected. And so I'm happy to report that my research shows, in researching the book, that most presidents have vastly complied with Supreme Court decisions. But there have been close calls. President Jackson was the most graphic example of a president disregarding the decision of the Supreme Court, which led to the Trail of Tears, which was a tragedy. We've had other instances where the presidents have been tempted. An example would be President Richard Nixon in the 1970s, when the Supreme Court ruled that he had to produce the tapes of the secret recordings in the White House. The president had argued that the executive branch is hermetically sealed from the other branches and can do whatever he wants. Supreme Court unanimously disagreed with that. Richard Nixon complied with the decision. What would have happened if he said no, and I'm staying here in the White House, I'm not going to resign? But he did comply with the decision, and then about 10 days later, he resigned the presidency. Dwight Eisenhower would be another example, the Brown versus Board of Education case, where the Supreme Court ruled, with Justice Jackson voting, that the public schools, that the segregation of the public schools on the basis of race is unconstitutional. President Eisenhower reportedly was not a great fan of that decision. He was a more conservative president, but he's the one that sent out the troops to various southern cities to make sure that black students could attend schools. He may not have agreed with the decision, but he complied with it. We're even seeing that played out today, I would argue. President Trump clearly was not enamored with the Supreme Court's recent decision invalidating his tariffs, but he is complying with it. Now, the current president is trying to justify the tariffs based upon other laws, but he is complying with the Supreme Court's decision under the particular law that was at issue in that case. So yes, there have been instances where presidents have disregarded Supreme Court decisions. They've been few and far between, and this country, one of the points of pride that this country should take is that for 240 years we have developed a culture of compliance, including by our presidents. It's ingrained in our system that decisions and orders by the judicial branch are to be complied with. It's not to say that that may not be the case in the future, and if so, it would lead to a constitutional crisis. But the history of this country has generally been a history of compliance. But your question is a good one because it points out that the judicial branch can enforce its own decisions. It relies upon the two political branches to do it.
It also, while we're moving through the next question, it also brings up an interesting parallel to Truman's time, that there were laws on the books at the time that would have allowed him, from the Union perspective, to do what he was trying to do by seizing the steel mills. He just didn't like those laws.
Right.
So that's not what he used as his justification.
Right.
And so this idea of, well, there are laws that exist. If the president chooses not to use those as the justification, that shapes the court's analysis of that action.
Correct.
Thinking about any or all of the three branches of government, I want to ask a question using a word that I've heard more in the last few years than in my entire life. Are we living in unprecedented times?
It's a good question, and I know that many people think about that. I think that your answer to that question depends upon your approach. If you look solely at contemporary analysis, you might be very concerned about the future direction of the country. One reason why I wrote the book is because I didn't want to limit myself to solely contemporary circumstances. I wanted to go deeper into history. And when we do that, this is what we find. After the nation's birth in the 1790s, Congress passed sedition laws, which outlawed dissent. President Jefferson, arguably, including with Aaron Burr, used the criminal justice process to go after his enemies. This was right after the country began. If you fast forward to the 1860s, this country had, as I said before, the greatest crisis a country could ever have, a civil war, 500,000 Americans dead, 11 states seceding from the Union. And if ever there was a time when people thought that the American experiment was going to die, it would have been during the Civil War. Then if you fast forward to the Great Depression in the 1930s, millions of people lost their jobs and their savings, banks failing left and right, people on food lines. If ever there was a time that a dictator would rise, sort of the way Julius Caesar did, that would have been the time to do it. And then if you fast forward to the 1960s, with all of the upheaval, political assassinations, riots in major cities, and the like, people thought again that the American experiment was doomed. People, during the time of their lives, during their contemporary lives, sometimes feel that the situation that exists in the country is existential. Certainly that's how people felt during the Civil War, how they felt during the Great Depression, some during the 1960s. But here we are. Here we are, 240 years, imperfect as it has been. The Constitution is still standing, and the like. So for me, when I widen the lens, I remain cautiously optimistic that we will proceed as a republic. That's not to say that there won't be bumps along the road and that there haven't been, but all people during the times that I mentioned felt the existential threat of their contemporary circumstances, and the country continued. So I think that if you take a deeper dive into American history, I think that it could potentially assuage whatever anxieties there may be about the present time. But if you limit yourself solely to what is going on today and the analysis of what's going on today, you might be quite concerned. So my suggestion is broaden the scope. Broaden the scope. This country wasn't founded last week. We've been around for nearly 240 years. There must be a reason for that. But the trajectory has not been perfect. It's been very much imperfect. Slavery and the like, it's been very much imperfect. And also to keep in mind the words at the beginning of the Constitution of the United States, in order to form a more perfect union. The framers didn't say to form a perfect union, because they know that's not attainable, but in order to form a more perfect union. We are always, as a country, striving towards perfection, knowing that we'll never reach there. So that would be my answer to that question.
We talk a lot about the cycles here in terms of pendulum swinging, and because for all of us, it is usually the first time we are confronting these issues. It feels unprecedented. But I've actually really come to hate that word. Like nothing is unprecedented. You just have to figure out how far back in history do you need to go to find that example.
It's not to say, and this is what Franklin was getting at when he said a republic, if you can keep it, that it's up to each generation, each succeeding generation, to remind itself of the first principles that gave rise to this country and which gave rise to the framers' vision for the country. So it's not to say it's a gimme, because James Madison, Alexander Hamilton, Benjamin Franklin, they were students of history, and they know that democracies can vanish. That is why James Madison, before the Philadelphia Convention, huddled himself in Montpelier and read every book he could find on the subject of the success and failures of republics throughout human history, because he wanted to come to Philadelphia putting those safeguards in the Constitution to make sure that we survive, because he knew, and the other framers knew, that democracy is precious, it's fragile. But here we are 240 years later. It's quite an achievement. And so if you broaden the lens, I think you'll be a bit more cautiously optimistic than perhaps the present media or present analysis would say.
I think we have time for one more question.
Sorry, this is a deep in the weeds question. You were talking about the steel seizure concurrence that ended up carrying the day. And I've been trying to rack my brain to think of another concurrence like that. And I'm wondering, and I don't recall this, but maybe you or someone else here does, whether the Powell opinion in University of California v. Bakke was a concurrence.
I don't remember.
I don't know.
I'm thinking it was, but I may be wrong. But it doesn't carry the day the way the steel seizure concurrence does. But it did carry the day for a while. It occurred to me, if that's even a concurrence, and I'm not sure.
Well, some decisions are by plurality. Sometimes it can get, when the Supreme Court on a case is fractured, it can get very confusing. What is the governing law of this case? A plurality sometimes can result where there is a sufficient number of justices on a rule of law, but there isn't a sufficient number of justices on the way they got there. I can't recall if Bakke is one of those cases. That was the university case, affirmative action in university enrollment, if I recall right. But I would have to say no, because I think that we'd be more familiar with the concurring opinion in Bakke. Justice Jackson's concurring opinion in Youngstown is forever. And there have been several Supreme Court decisions after it that explicitly have cited Justice Jackson's concurring opinion as either the governing framework or the guidelines to be used in examining the expansion of executive power.
Peter, thank you very much for sharing your thoughts with us this evening. We really appreciate it. It's been a wonderful experience to have this conversation.
Thank you so much for having me.
Yeah, absolutely. And I would like to thank all of you for joining us as well. And you can learn more about our upcoming programs in the 25 Years of Asking Questions series, as well as our virtual series commemorating the 80th anniversary of Nuremberg, as well as, once again, to how to support our programs, our mission, and our work at our website, roberthjackson.org. Thank you so much.
Thank you. Thank you.